Okay, so let's get started. Welcome to all of you. My name is Tim Webster. I'm an assistant professor here at the law school, and this is the panel Probes and Bribes. I still can't say it. Practitioners' perspectives on the FCPA. Next to me are three eminent lawyers whom I will introduce momentarily. But first, I want to express my gratitude to all of you and to our panelists for coming here today, and to tell you why it is that we are convening this panel on the FCPA. There are a number of reasons. First, and perhaps most proximately, I'm teaching international business transactions this semester, and this is an important topic in international business transactions. And I thought, what could I, how could I make this exciting for my students? And so I invited three of Cleveland's best lawyers to explicate and to illuminate what the FCPA looks like from a practitioner's perspective. Secondly, I wanted to address the long-standing complaint that people, and students in particular, don't learn anything practical in law school. You hear that a lot, and so what this panel will show you, I believe, each of these three men has deep experience with the FCPA. Their law firms, whether here in Cleveland or in Shanghai or in Beijing or in Europe or in South America, in Rio, what have you, also do a lot of FCPA work. So this is something that students very likely will have experience with once they become lawyers in the near future. And another purpose is to actually show off some of our alumni. The only alumnus we have with us right now is Colin Jennings, way at the end. Initially, I had invited Jim Wooley of Jones Day, who had to bow out at the last minute. Luckily, he sent in his stead the man in the middle, Justin Herdman. So Justin, thank you for filling in for Jim on such short notice. And again, I will talk about their bios in a little bit. Let me first explain a bit about what the FCPA is. I realize I have maybe a quarter of my class here, but I have a lot of people who may not know what the background to this law is. So I'll touch briefly on that, then I'll turn it over to the panelists. They'll each speak for 10 or 15 minutes, and then we'll open it up to questions and comments from the audience. The FCPA was actually passed in 1977 after the Watergate scandal, and after revelations that were revealed during the Watergate scandal that many large U.S. companies had bribed foreign officials, the Prime Minister of Japan, Prince Bernhard of the Netherlands, a number of German officials, Italian officials, and so forth. And a Senate investigation found that some 400 U.S. companies had bribed foreign officials to get business in their countries. And this was, of course, intensely embarrassing for the U.S. government. And Congress reacted with the FCPA in 1977. So from 1977 and for several decades thereafter, the U.S. was the only country in the world to criminalize, to prohibit its companies from bribing officials. This is obviously a huge competitive disadvantage. If you were an American company, you couldn't bribe. If you were a German company, you could bribe. And so there was an uneven landscape for quite a few number of years. Ultimately, other countries followed suit. And eventually there was an international convention, the UN Convention Against Corruption, that deals with the issue of bribing foreign officials. But for those who think that US unilateralism is always a bad thing, I would suggest, well, sometimes it can actually be a force for the good. Now, you've probably heard about some of the FCPA prosecutions or cases that have made the news recently, Walmart most recently, but also JP Morgan, Morgan Stanley, and a number of other US companies have been caught up in FCPA investigations. Most recently, the most recent revisions to the FCPA actually allowed foreign companies that do business in the US or list on US stock exchange also to fall within the FCPA's ambit. And so now we have Japanese companies, German companies, companies from around the world also finding themselves in hot water with the FCPA. And so this is a law, again, with a truly global reach. It's practiced here in Cleveland, as our practitioners will tell you, but it has a broad influence around the world. In fact, Colin, Mr. Jennings here, was in China last week doing FCPA investigations, right? So this is, he's still jet lagged, but this is something that's obviously on his mind, whatever time zone he may be in. Most recently, under the Obama administration, the Department of Justice has really ramped up its efforts to enforce the FCPA. There have been several multi-hundreds of millions of dollars of settlements that the DOJ has wrought out of a number of companies. And we know that the DOJ is conducting its own investigations, just as Squire Sanders or Squire Patton Boggs or Jones Day may conduct its own internal investigations. The DOJ is also doing that to make sure that these law firms are providing good advice. We know that the DOJ is using wiretaps, is using surveillance, is using border searches, is using maybe not enhanced interrogation techniques, but is using a much broader toolbox to enforce the FCPA than, say, it did 10 or 15 years ago. And as a result, as I've said, we've seen 9 out of the 10 largest settlements from the FCPA handed down in the past 5 years. And again, these range $500 million, $700 million, $800 million settlements that companies are striking with the DOJ to extricate themselves or extract themselves from FCPA investigation. Before I introduce our speakers, I will just add that it has generated a huge amount of business for U.S. law firms. Whenever I go to China and I ask people, lawyers of my age, my cohort, what they're working on, they say almost categorically they're working on FCPA stuff. So at the very least, it keeps all of us employed. Let me turn very briefly to introduce our very impressive and accomplished panel here. To my left and to your right, we have Mr. Kevin Barnes, who is an eminent international lawyer. He is the managing partner of Taft, Stettinius, and Hollister here in Cleveland, and has practiced law here for 35 years and advised on all matter of international business transactions involving countries, over 24 countries on 5 continents. So he's, as I said, a truly eminent international lawyer. He is very knowledgeable about international finance, has worked on a whole range of projects, project finance, trade finance, asset securitization, and so forth, and even had his own private equity firm in the early 1990s. He is a graduate of Harvard College and Harvard Law School, although he has been in Cleveland since 1979. In the middle of our panel, we have Justin Herdman, who is a trial lawyer at Jones Day. He is a former assistant U.S. attorney and brings a wealth of experience both from the federal government's perspective and also from the private sector to his job at Jones Day. He has been involved in corporate criminal litigation. He's also done a number of internal investigations for the FCPA in Europe and in the Middle East. And I'm pleased to note that Justin's actually taught international criminal law at this law school since 2006. So you can actually take a class with him next semester, maybe?
It's actually this semester.
This semester. Okay.
Next semester is national security law.
Which you're also teaching?
Yes.
Okay. So he is a man who is frequently around these halls. To the far right, geographically, if not politically, we have Colin Jennings, who is a trial lawyer at the newly merged Squire Patton and Boggs. He too has extensive criminal and trial experience and a wealth of experience with the FCPA as well. As I said, he was just in China last week working on FCPA matters. This is, as I said, very close to his own mind. He has written several articles about his experiences and insights, including one that I found particularly apt called "Avoiding Criminal Liability for Corrupt Practices Abroad Through Effective Corporate Compliance." I'm sure this will hold great interest to all of you, and perhaps Colin can draw on that in his remarks today. Finally, I'll just add that Colin is a graduate of this law school. He graduated in 1997, so all of the students here can say, okay, this can be me in 10 or 15 years. So I'll stop there. Our first presentation involves PowerPoint slides, very fancy, and will be given by Kevin Barnes of Taft, Stettinius, and Hollister. Thank you.
Thanks, Tim.
Sure.
And I'm pleased to be here with Justin and Colin. Two guys that actually know what they're doing, so you'll learn something, I'm pretty sure. So I have to correct you on one thing, or maybe 2 or 3, but I'm not the managing partner of Taft. I don't want my managing partner to come beat me up. He's a lot bigger than I am. I'm the partner in charge of the Cleveland office of Taft.
Thank you.
So, in imminent danger maybe, but not imminent. Not. So anyway, so let's So, in the interest of full disclosure, these are repurposed slides because, as I said to Tim, after 35 years of practicing law, I don't do anything new. If it's not in my form files, then we're not doing it. So, let's flip to the first one. So, what we try to do, and I'm a corporate lawyer, I'm a business lawyer. When Tim said we were going into the new courtroom, I got a little scared because I haven't been in any kind of courtroom for 30 plus years. So, anyway, what we have, and I think what we're seeing generally, and most of my clients are mid-market type companies, sales anywhere from 25 to $1 million to $1 billion. I do some work for public companies. It's not in this area, so I'm sure both Justin and Colin can talk about some of the public company aspects of it. I'll touch a little bit on it, but my concern mostly is with mid-market companies. And what we've seen obviously is those companies going into other countries doing a lot of business. And so all of a sudden, and I have a little client, just on the Near East side, they do business in about 13 countries worldwide. They're an 80-year-old metal bender, as we like to call them in the trade, and they literally do bend metal and make it into interesting products. But they're into business in about 13 different countries. And so we've just seen a growing sensitivity to, geez, am I doing things right in the international setting? Secondly, what we've seen is, this might sound a little too corporate America promotion, but we've seen a much more of an interest in compliance by a lot of companies. I know you're probably thinking like, yeah, well, not so much J.P. Morgan, or probably these are all these guys' clients, but there is really a growing devotion to compliance and doing it right. If for no other reason is when Colin and Justin talk, they'll tell you how expensive it is if you do it wrong. So if you're really thinking about preserving shareholder value, you don't want to do it wrong, you want to do it right. So what we do is a client comes to us, and most frequently we have a client that's had maybe a bare 2-paragraph policy about compliance with the Foreign Corrupt Practices Act, if that. And they say, geez, somebody scared the pants off of us about we didn't have a very robust policy and practice. So they say, what can we do? And we'd say, well, we need to put a program in place for you. And so we start with, we've got a program, these guys do, and every law firm that's, if you guys crib these PowerPoint slides, you can be Foreign Corrupt Practices Act lawyers too. So let's flip along. Sure. So the first thing we say to the client is, geez, we got to figure out where you're at risk. Because, look, if you're only place you're exporting to is Canada and you're not really dealing with any state-owned enterprises up there, your level of risk is pretty low. So what we try to do is, what we found is clients are relatively averse to paying high legal fees. That's just something we found. So we're always trying to tailor what we're doing to what their business is. And, the key is understanding what their business is. And so the first thing we do is, let's say, tell us what your risk, let's figure out what your risks are. So, you can flip now. Sure. So we go, and this is, some cool thing that somebody dreamed up. Actually, this was dreamed up by one of my partners who practices full-time in this area, and he's come up with this. But so this is a way to sort of say to the client, here's what we're trying to do. My time is up? Oh, I guess not. Okay. So then what we do is say, okay, we're going to figure out where are you at risk? How bad are you at risk? How do we figure out how to control it? How do we give you a program that really works? And I think Justin will tell us as a former prosecutor is, if you have a program but you don't use it, it's probably not very good. but, and then how to continuously monitor it, to know that you're doing better at it, so we can flip along. So here's when we get, and I think we go to the next one. This one's probably. So we say, where are you doing business? Who are you doing business with? Where are your opportunities? Who are you, what kind of business relationship do you have? How do you develop your business? Where do you rub against the government? You know, what are you telling your people, and what are you getting them to commit to? So we try to, you know, sort of what they don't know, I guess I should say, and what they're not willing to do. And you'd be surprised in businesses how many things people are not willing to do. It's just a fact of life. So we then try to go and say, and this is probably one of the things that, very difficult, but you need to go to the board and to the CEO and say, you need to be actively committed to doing this. Because if it doesn't start there, it's not going to be, you're not going to go very far. And then you also have to say to the client is, what kinds of resources will you devote to doing this? So we go through this, and let's flip it, we can flip now. So first thing we try to do is get people to buy into a code of conduct. And you're probably thinking, well, so how hard is that? It's very difficult in the real world, because what you want is something that everybody, and particularly if you have a business, you know, a multinational business, where you've got people that are working in 10, 15, 20, even more countries than that. I think these fellows will tell you this is, they come from different backgrounds, they've worked in different environments, they've dealt with, so you're trying to come up with something that is meaningful, but that people will buy into. Because if they just, again, if they read it and throw it in a drawer, it's not really valuable. So try to come up with some policies about how they should do things. You know, record keeping and accounting, and again, I think, was it Colin, were you talking about this beforehand? I think the accounting.
The
Yeah,
accounting provisions?
Yeah,
Right.
yeah. No, I'm not an accountant. You know, some of my best friends are accountants, but I'm not one. But this is a very, very tough area, and so because you know it's not the crime, it's the cover-up, so to speak, is the answer there. And so you really need to have buy-in on the accounting side. Now, of course, your external auditors will do it in a second because it's just more fees for them, but it's really getting your internal, making sure your internal controls work on that. Communication, that's just making sure people know what they're supposed to be doing, et cetera. I was on the, what's that thing, you guys see this, the FCPA report, that little internet blog. Yeah, well, they had a thing today about, hard to believe that somebody wrote an article about tips for hotlines or helplines. You know, and again, I'm sure we'll hear a little bit more about those. But say to, you know, how is that chain of communication going to work? A lot of people don't want to talk to, you know, they're not going to tell they don't even want to rat out on their boss, or they don't want to, you know, rat on their boss to their boss's boss. You know, they don't know what the ramifications of that is. So how do you do that? You know, and how do you assure people? There's a lot of people that when you tell them that, yeah, this is confidential, nobody else will find out about it, they just don't believe you. So you got to be able to convince people of this. So what are we here at? Okay. My page is behind. So this really sort of says, guys, we're gonna have procedures. We're gonna tell you, you know what, you can't take $10,000 into the purchasing agent's office for the state oil company of Dubai. You know, don't go in there with $10,000. You know, if somebody asks you, and it's pretty interesting, you know, I see emails. Maybe one of the fun parts of this job is when you get the emails where people are asking for bribes. It's very interesting to see. I was working on a deal in Vietnam about 3 or 4 years ago. We were very close, very complicated deal, lots of layers, et cetera. It was a state-owned enterprise there. And we spent a lot of time, my client had worked up a very innovative proposal to deal with an issue in Vietnam, and we got right down there, and then there it was. General Tran feels that it would be very appropriate for you to demonstrate your good faith by making a contribution to, I can't remember if it was a school or a hospital or something like that. And so months of hard work, it's just, because we went back through the chain and said, sorry, General Tran, we're not going to make a $50,000 gift to the hospital, or I can't remember which one it was, but that was just, so, but you see those emails, and it's sort of, people try to be clever about them, but at the end of the day, you have to have people to recognize that. Again, I'm not going to talk about record keeping accounting. It's probably, maybe if it's not it's certainly one of the top 2 or 3 most important things. Let me talk about business relationship due diligence. So, in most of the world, people go to market usually through distributors. Sometimes they'll go to market through some other kind of agents, but they're going to market. Not many businesses, until they're established, go to market directly. They don't have the language skills, they don't have the familiarity with the customs, they don't know the laws of that country, so they go to market through third parties. This is probably one of the most difficult areas. Again, I was looking at that FCPA report, and I kind of chuckled to myself, because they said 9 clauses you must have in every distributor agreement. And I thought to myself, I'm lucky if I can get 3 sentences in one. 9 clauses. I mean, the sensitivities. Frankly, a lot of people say, "Do you think I'm a crook? Why did you put this in this document?" I've never done that. Why do you think that? And you say, it's there for both of our protection. But there's a negotiation. The idea that you can impose your will on your third parties, that's not a reality. You need to be sensitive, and it's a little bit of an iterative process where you go back and forth negotiating the provisions, and then when you get to the point of saying I do need to be able to have the ability to come look at your books, and of course they automatically think so you can figure out how much margin I'm making on the products of yours I'm selling? No, we're not, we just, so you can figure out how to go around me? No. So that's a very interesting. Anti-corruption incentives, and I would put this in a broader rubric. I have a client that's in a relatively dangerous industry, and about 15 years ago we wanted to improve our safety. And so one of the things we did was we built in an incentive for safe behavior. And it is now part of the compensation review, their safety record. From if you're a truck driver, if you haven't had any accidents and and all the way up the chain to the transportation manager and then the division manager, et cetera. So one of the things is, it's an amazing motivator, money. You'll probably be all shocked to hear that, but it really does make people pay attention and try to do the right thing. So those are all things, and they still have to fit within your corporate culture. If you come in and try to impose something on a corporate culture that they haven't had before, I guarantee you it's not going to work. It's not going to last too long. Now we go to talk about sort of detection. A lot of this is a burden both on the your internal auditors, your internal financial people, your internal accountants. They have to be given the tools to be able to figure out whether something, and this comes back again to the record keeping. Did somebody actually pay a bribe? Where did it? Listen, if you're down in a 4th-tier subsidiary doing business in Guatemala, you're going to try to track that down. What that? Where did that money actually go? Did it really go to pay a bribe, or did it really go to pay somebody's hospital bill because their kid broke his leg and you wanted to take your employee's kid to the hospital, and and so in order to get him the care, you took $5,000 out of petty cash. It's very interesting. So we've talked a little bit about hotlines, incentives, protections, internal reviews and investigations. You're going to hear a lot about that more from people that actually do it and are good about it. And we can flip over. And I think, again, I think we'll hear more about on these slides, how do you respond into the things that you need to be aware of. So let me come and talk a little bit more about maybe some other more practical items as well. This is a hot topic in M&A. I spend a lot of time with my M&A practice group, and for lack of a better word, I'm sort of the jack of all trades, or the Swiss Army knife of the compliance lawyers in the Cleveland office of Taft. So if somebody has a question about whether it's FCPA or ITAR or BATFE, any of those things, they're sort of coming to me, well, Kevin, what, dot. And again, I think both Justin and Colin will hold me up on this one, is that now in any kind of M&A transaction, the compliance review is a very significant part of it. I was working on a deal, we were selling a client. And Kirkland & Ellis, one of the biggest firms in the country, if not the world, actually hired another law firm to do the compliance review. I was like, really, Kirkland & Ellis doesn't know how to do this? I was a little shocked, but it was a very nice, it was a cordial, but it was a thorough review of any number of the business practices that this client did. And they wanted to know, and they were tracing things all the way down as far, because, and again, I'm sure maybe we'll hear a little bit more about this, is, there is no such thing as the corporate veil to a prosecutor, at least in my mind. The risk for successor liability in a business transaction is so substantial. So one of the things you say to companies, and we represent a number of private equity funds, well, they're always going to, whatever business they're buying, they're always going to sell. That's a guaranteed. If it doesn't go bankrupt, they're going to sell it. So they need to know when they're ready to sell it, it can be sold cleanly without issue. So one of the things that you're sort of charged with is if you buy say a mid-sized company, it's $50 million, and all of a sudden they're starting to go to market in Latin America. Well, okay, guys, it's a different world, and who are you selling to? And that brings us back to one of those early slides. Who are you selling to? How are you going through that process? So, a couple of other things. So I have one of my clients, a fairly large multinational. Every year they bring in all their top managers. I mean, I think everybody that's above a sales manager from about 40 different countries. And they're kind enough to allow me to spend a half a day talking about compliance. And one of the topics they always want me to talk about is the FCPA. And of course, there's a broader world. There are now the UK Bribery Act, which I know enough about just to mislead you. But there's a much more rigorous international framework of anti-corruption laws and policies that you need to pay attention to. And so when I talk to them, I've got PowerPoint slides with all those laws, and sort of here's dot, 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 dot. I mean, you can scare people in at least 6 different languages if you try hard enough. And but that's first a sensitivity to it, and then a commitment to what I call enterprise-wide training. And the challenge with training is you got to make it fit right. You're going to do different training for salespeople than you're going to do for sales managers, than you're going to do for division managers. And as you go up the chain, as you go all the way up to whether it's a country president or a regional president, or however that client is organized. So you have to be able to figure out how to do that training and deliver it effectively. And then, and the one thing about this, and again, I'm sure we'll hear more about it, is this needs to be a continuous cycle. It's not annually. I think I think with most of my clients, we sort of view this as every 2 to 3 years, and don't tell me that's wrong, or if it is, tell me it's wrong, so maybe I go back and sell them. But because, frankly, you'll be surprised to know that businesses actually have other things they need to do besides compliance, and so their willingness to devote constant resources to compliance, if you're a really big company, I happen to know the person who heads the compliance effort up at Cleveland Cliffs. Very, very smart person. But I don't even know how she does her job. I wouldn't want it. But she's constantly trying to figure out, how do I communicate this? Because how does this get done? And again, I'm sure you guys work with clients that way as well. So there's a balance. If you're a huge multinational, you probably got a compliance staff of 50, 100, maybe even more than that, type of thing. If you're like my clients you've got a compliance staff of maybe 3, 4. You can't burn them out. And they're not only just doing FCPA stuff. They're doing export controls. If they're making sure their export controls. They're a public company who, again, that's not a bailiwick I practice in. Now we have conflict minerals. I mean, the list is never ceasing. So let's sort of just flip it to the last of these slides. Oh, okay. So here, this will just give you a little clip. So here's we have 74 deliverables that we'll give to a client to say, here's how you put your policy in place. Now, frankly, does every client take all 74 deliverables? No. But we've got this package of deliverables that we bring to them. I think that the ones that I want to highlight is, I like, what are you doing with, if you're going to market through distributors, as we talked about, what are you doing with those distributors? It's very interesting. In one of the industries I work with, there was a huge lawsuit about 5 years ago that was filed. It was an international manufacturer was trying to terminate its Mexican distributor. Mexican distributor was a U.S. company that was distributing in Mexico, and before they got all the pleadings under seal, I got a chance to read some of them, and I thought, oh wow, and it was a huge fight because it certainly looked like there was evidence that the distributor had been bribing officials at a Mexican state-owned enterprise. Looked that way. Now, all of a sudden, all the pleadings got put under seal. The case got settled. I don't know whatever happened to it because nobody ever talked about it, but it was fairly interesting that one of the rare instances where you saw an issue where back and forth between where it really boiled over between the distributor and the manufacturer. So, but that's, again, those are the people because, you don't control them, but you need them. But they can get you in trouble just as badly as any of your employees can get you in trouble. And then, again, if you come back to the scenario, if you're going to sell, if this company is going to be sold or this division is going to be sold, et cetera, I guarantee you, when Colin's firm or Justin's or Kirkland & Ellis shows up to do the diligence, they're looking at all that documents, and whether it's one of the big accounting firms or another financial review firm, they're going to go through and start to look at stuff and pull samples. So, let's flip over here. We've talked about M&A. Employees. I think this is very tough. Again, it comes back to culture. You've got employees who, you hear this. I hear this frequently, and if you read any of the business press, the biggest issue for most companies is human capital. It's just to be able to attract and retain human capital, very difficult, very challenging. So if you, I won't say the colloquialism. If you make your employees unhappy, guess what? They leave. And if they leave and they go to competitors, then you have to sue them for breaching their non-competes, and that's more expense for lawyers, and that's not a very happy result for most people. So, again, you have to do it right. but you also need to do it with a certain level of sensitivity. So I think that's where I'll stop. And
Okay.
we'll hear
Excellent. Well, Kevin, thank you for your comments, and I think it's helpful for us to realize that it's not just J.P. Morgan, it's not just Morgan Stanley or Walmart. Walmart's also, mid-market companies here in Cleveland that are also worrying about FCPA as they go to market, as they distribute their products, as they invest abroad, and so forth. Great. So, Justin, can you take it away?
Sure. I thought my most helpful contribution on perspective would be from the enforcement side. As a former prosecutor, just a quick story for you. I often tell people that if I'm ever reincarnated, I'd like to come back as an FCPA prosecutor. And they say, why is that? And I say, well, on one of my many trips to Main Justice when I was an assistant U.S. attorney, I was working off, a couple minutes of sleep. I'd been working for several weeks on a case. I was running around the halls of Main Justice, scurrying around, trying to figure out how we were going to find this one crucial piece of evidence that we needed to prove our case. And I bumped into a friend of mine from law school, and I said, oh, what have you been up to lately? He said, oh, I'm an FCPA prosecutor. And I said, oh, you've been pretty busy. He said, oh, yeah, I've been working really hard lately. I'm getting ready for this big meeting today. I said, oh, so there's a meeting today? And he said, yeah, this XYZ company is going to come in and they're going to tell us everything that they did wrong. I said, you mean they're just going to come in and tell you the crimes that they committed? And he said, yeah, but we have to be ready to make sure that we can, ask them questions and make sure that we're prepared for it. I thought, okay, well that doesn't sound so tough. I think I could probably handle that job. And in reality, it's a little bit more difficult than that from the FCPA prosecutor's perspective. But there is quite a bit of reliance on companies to self-report, and there are reasons for that. One, probably the primary reason, and one of the reasons that I think gets maybe lost in the shuffle when we talk about multinational corporations and their operations in many countries around the world, is that the U.S. government does not have quite the same reach, flexibility, the ability to move as quickly as multinational corporations do. And so a couple points to illustrate that. The first is, if you pick a country that has typically a higher FCPA risk profile, say China, that's one that typically gets mentioned. We'll let Colin speak to specifics on that since he just got back. But if you take China as an example, it really illustrates a lot of the difficulties that U.S. law enforcement has in actually enforcing not just the FCPA, but any law that is extrajurisdictional, extraterritorial jurisdiction. The reason for that is multifold. One is that the typical tools that are available to a prosecutor are not always at the ready when you're talking about a foreign country. Even those countries that we have very close law enforcement relationships with, it's difficult to get things to move. So when I was a prosecutor, if there was a case that was heating up and we knew that we needed to execute a search warrant, it was pretty easy. The agents and the prosecutors would all get in the room together, they'd talk about the evidence, they'd put together an affidavit, you'd run down to the courtroom, you'd get a magistrate to sign it. You could do it if you were moving quickly in a couple hours. That was possible. And if you really needed to move fast, you could do it orally. There's an ability to apply orally and not have a written affidavit. You can paper it later. You cannot do that if you are wanting to search the factory that's in Chengdu, China. That you're not going to be able to move just as briskly as that. And in fact, you're probably not going to be able to do it at all, because the limits of U.S. law enforcement, they stop at the water's edge, and they are only reconstituted in some form or fashion to the extent that there's a treaty in place, a mutual legal assistance treaty with a foreign country. And so what that means is that, first of all, there's got to be a treaty, and it's got to set out what U.S. law enforcement would be enabled to do in those foreign countries. It also means that you have to rely very carefully on your foreign law enforcement partners. And there are some foreign law enforcement partners who are more eager to work with the United States than others. Depending on what week it is and depending on what particular
criminal prosecution, and then one of our lawyers in Washington was just appointed the monitor for Weatherford, who just paid one of the top 10 FCPA fines in history. So soup to nuts, we have a very active FCPA practice. Now, when I'm going to sort of talk about where the wheels have fallen off, these are real examples and cases that we worked with. I'm going to change the facts and circumstances enough so we're not actually talking about client confidences, but it's much easier to sort of talk about real issues where the wheels have fall off, because you're not seeing the issues where you're slipping an envelope of cash across the table. That still happens, but most people are sophisticated enough now where you're not seeing just cash being pushed across the table. You're seeing, the emails like Kevin talked about saying, we'd really like you to make a charitable contribution to this school, to this political party. Those are considered bribes, and there have been prosecutions on those. The most amusing one that I've ever seen is when someone's actually, and these are small bribes, someone was leaving an African country and the immigration official says, well, you can't leave yet, you need to be immunized. And then he pulls out a syringe, it's full of black liquid with a rusty needle on the top, and says, or you can pay a $50 fee. I'd pay the $50 fee. She paid the $50 fee. That's technically a bribe, but ultimately you're the victim of a crime at that point. I don't think there's a prosecutor on the planet that would charge you for that. I would hope not, at least, but you're not here for the
I wouldn't bet
department.
on that, but I hope that that's not the case.
We'd defend you if it comes down to that. Other issues that happen a lot are for example, we had a bunch of goods coming into a Latin American country, $3 to $5 million worth of goods that were going to go into a processing plant. The officials in that country would not allow the materials to leave the dock because they said, we need to have balanced imports and exports. So unless you're going to export goods of the same amount, we're not going to let you import your goods, unless, of course, you want to pay a gratuity. And the client calls and says, can we do this? We say, of course not. And they said, we knew you were going to tell us that. So they ultimately had to leave the goods on the dock, and actually they thought that the foreign government official would capitulate. He didn't, and the goods are actually still sitting there today because we said you have to walk away from them, and they actually left business in that country and moved it to another country because they just decided they couldn't do business there. Another similar example is in Mexico. We had a client right after NAFTA start building a plant there. Slowly but surely, they're paying small bribes here and there to get things done. About 18 months later, the Mexican IRS official shows up and says, we're not going to process your tax form until you pay us $10,000 US. Client decides to leave Mexico because ultimately they figured out that because they started paying small bribes, that was enough. They had been sort of marked as a bribe payer. They were forever sort of doomed in that market. Other sort of fun, interesting issues are someone goes down to an air show in a Latin American country. The general says, I have my own airplane. I'd really like a hangar, but if you give me a hangar, what I'll do is I'll make sure that we buy from you. The salesperson comes up and says, this is great. I just have this new line of sales. The CEO says, I know we can't do this. He says, no, it's a sample. The purchase order says sample. We just gave them a sample. I said, no, that's a violation. It can be a sample, but you got to take it back. I'd say, well, that defeats the purpose. Well, if it's supposed to defeat the purpose, you're not supposed to be paying bribes. So bribes can be anything of a gift, a value, anything like that. So you've got a whole slew of sort of interesting ways that people come up with taking money out of a transaction. We've got one situation, and this happens a fair amount in Eastern European countries. If you have a distributor in place or an agent in place, there'll be one contract with the manufacturer, another contract with the state-owned enterprise, and there's about $50,000 to $100,000 difference between the two contracts. And in the U.S. company's only seen the one contract and doesn't realize that there's an extra $50,000 to $100,000 on the back end because they haven't demanded transparency through the entire transaction. That ultimately is a bribe, and the prosecutor's office would say, you failed to do your due diligence, you're responsible with that $50,000 to $100,000 bribe. So there's a lot of very creative ways to pay bribes. And the other thing that's sort of, you always sort of hear people say, well, that's just the way we do business here. That's just the way we do business in India. That's just the way we do business in Brazil. That's just the way we do business in Russia. Whatever it is, you hear that all the time. And in fact, one of the most interesting things is in India, the sewage group will actually turn off your sewer, and then 3 days later, they'll show up and say, would you like your sewer services turned back on? By 3 days, you really want your sewer turned back on. And then all of a sudden, their hands come out, and you have to pay something to get your sewer back on. Otherwise, they're just simply not going to turn your sewer on. So you essentially have a problem with, low-level state employees shaking down businesses through the syringes or turning off your sewer. That's sort of the small side of the problem. The bigger side of the problem is the sort of the general saying, give me a hangar and I'll steer the Air Force's business to you. You have sort of that whole gamut that U.S. companies have to deal with. One good thing, particularly in China, the crackdown in China has been incredible. In the last about 4 years, you've seen a sea change in Chinese culture with respect to corruption. In fact, there's a concept called gongqi in China where it's sort of the relationship, and it always was sort of code for a bribe. But now it's turning into more of what is a relationship in China. And in fact, party officials, apparently the price of red wine has dropped dramatically because party officials are no longer having these lavish dinners, buying all sorts of very fancy wine and things like this. Now everyone has a working lunch, and there's still wine, but the wine's under the table, and the party officials will not actually touch the wine and pour it for you. You have to reach under the table and pour it yourself because they're so concerned about what's going to happen. And in fact, there was a high-ranking Chinese official who was just arrested because he had a watch that was too big, and so they decided that because the watch was too big, it had to have been a gift, and therefore he was corrupt, and they arrested him. So there's just an absolute sea change in terms of China and sort of their approach to business, and so you're seeing sort of real penetration of, at least the concepts behind the FCPA. China has its own anti-corruption law. India has its own anti-corruption law. Russia just passed its own anti-corruption law. So it's much easier, I think, for U.S. businesses to do business abroad because now the concept of not paying bribes, it's not just American companies, it's now global companies that aren't paying the bribes. So you've really seen in a relatively short amount of time a very significant change in the world's approach to corruption. So,
I want to talk about, you were talking about some grease payment examples there. So where do you guys draw the line on these? Because, every once in a while I'll get that call.
yeah, well, we tell clients.
So does everybody know what a
none-
grease payment is? Or
Yeah.
I think it's referred to as a facilitated
Yeah,
payment.
there's an
but-
exception to
but
the
I-
FCPA called a facilitation payment, which is a grease payment. So it's a small payment to a low-level official to get something done that you'd be otherwise entitled to, so something with no discretion. So getting a visa application done or getting a customs document stamped so you have the proper stamp to have it leave. So something where it doesn't obtain, retain, or get a business advantage. So that's a grease payment. The Department of Justice has 7 factors that you have to go through to decide whether it's a facilitation payment. So we tell clients if you're ever in that discussion with the DOJ that this is a facilitation payment, you've already lost because you're 7 factors in. So that ultimately,
So you've got, again, I'm just a commercial lawyer, so what do I know? So you got a load, that's the goods on the dock. I mean, happens all the time.
Mm-hmm.
So you've got perishable goods on the dock. I'm taking over your role, Professor. You got perishable goods on the dock. And, if they're not into, whether it's the air-conditioned warehouse or into the processing line or something within 48 hours or 72, whatever the timing is. And so how much can you pay to get them? Because this clients ask me this question all the time. How much can I pay to get them through customs?
I would say don't pay it. I mean, it's really that simple. I mean, not to mention, we touched upon this a little bit, but another area of risk there is how you're going to book that payment, and if they're willing to book it as payment to customs official to facilitate shipment. That's pretty rare that somebody is actually going to make a payment and book it. It's also, I would say, not that common that, it does happen that people ask in advance if they can pay, but it's much more common that somebody says, oh, we paid this and we booked it as, that airfare or something like that, Is that a problem? That's usually...
maintenance. It's usually maintenance.
Yeah.
Right.
Something, maintenance, consulting fees, whatever it might be, something that's nice and generic. But if you ask me, I'm going to give the same answer that Colin gave, which is you're in a losing position. Once that money changes hands, all you're going to be doing is explaining what it is from then on out. Let's see if there's some other option that's available other than making a payment. Because once you do it, it's done, and then it's a world of hurt after that. It's just explanation after explanation after explanation. It's never a good thing.
Yeah, what we usually do is actually go to the person who says you need to pay a bribe. That's fine. We're not going to be able to, first, we're a U.S. company. We can't pay because it's in violation of U.S. law, and by the way, it's also in violation of your law. Either allow us to import the goods, or we're going to talk to your supervisor. That usually, particularly in the last 3 to 5 years, has been successful. The bigger problem is if it's the supervisor asking for the bribe, then you're in a little bit. Or we've had the situation where you go to the supervisor, and the supervisor says, "Oh, they asked for too little. We need more." We've had that happen too. Then you sort of leave the goods there and walk away and say, "Well, that was a bad idea." But you're sort of. We've seen situations. There was a situation in Mexico where someone needed to get some customs wrinkles sorted out, and the Mexican manager of the business decided to pay $10,000 through essentially a marketing company to the Mexican officials, booked it as electrical maintenance, and ultimately it was found out by the parent. The parent self-disclosed. We'll get into the whole debate of self-disclosure later. Ultimately, they paid millions of dollars of fines. They closed down the Mexican operation, all over $10,000. I mean, it's small money that creates just catastrophic effects for businesses. So, unfortunately, most U.S. companies understand that paying the bribe is not worthwhile. The issue is whether you can get penetration of that concept to your operations globally, and that's where most of the compliance focus is, because I think most folks in the U.S. know paying bribes is a no-no.
Unless they've been working in Cuyahoga County, then that's a little.
So
Wait, they were just misunderstood.
Justin, thank you for your comments. And I was reminded of my own brief experience in practice where I was working for a firm, and it seemed like we were always 2 steps ahead of the government, and they were sort of trying to get our client to do their work for them. So I think it's an ongoing challenge. And
That's not always the case. That's the ideal position to be in if you're a defense attorney.
Right.
But for my government friends who might be listening, we know that you're a couple steps ahead of us in some cases. So.
okay.
All times, right?
And then, Colin, I was really interested to hear about your own experiences. And one question I had for you, and then I'll open it up to the audience and give you guys a chance to ask some questions or make some comments as well. You mentioned how China is now going through a huge crackdown, and Justin raised the point about how efficient or how effective is the FCPA. Colin, you've done this stuff, and your firm has done this stuff all around the world. Can there be a cultural change without the host government, without China, without India, taking its own initiative to crack down on corruption?
No, I think you have to have. It's got to be a global effort, and I'm losing count of it, but I think we've got 40 new anti-corruption laws passed in the last 3 or 4 years. And you're seeing, passing the law is one thing, enforcing it's the other. So we've got, I literally was on the phone yesterday, or not yesterday, it might have been yesterday, I don't remember anymore, with someone saying that, well, yes, there's a law in India on anti-corruption, but no one enforces it. And we have a client who's in a situation where if they stop making the payments, they're pretty sure that they won't be able to get their goods out, which means that their supply chain globally is going to crash. So you get into some very interesting business discussions in terms of, okay, for $50 a month, do I really want to put my global supply chain at risk? Those are not fun conversation to have on any level with any client, because ultimately they've got real-world consequences, and they've got real-world responsibilities to their shareholders and the folks that they do business with around the world.
Sure. Great. Well, again, thanks to all 3 of you for 3 really stimulating presentations. Let me open it up now to the audience. You've heard 3 excellent presentations from 3 lawyers who know this stuff inside and out. And if you have questions about their practice, about what the FCPA means, or how they've experienced it in their own careers, please go ahead. Yeah, please.
So how does the defense work? Are you really saying how little do I have to pay, or are you saying you don't have to pay anything to your clients who come with and they need your help?
You're talking about making a payment, or you're talking about negotiating?
You're a defense lawyer
Yeah.
for companies that are accused of violating the act.
Uh-huh.
So how does that work? It sounds like it's just a matter of negotiating what they're going to have to pay.
Not necessarily. I mean, first you have to figure out what actually happened, and that's a large part of when you do an internal investigation, is determining whether in fact there has been a demonstrable violation of the FCPA. either the core part of the statute or the books and records portion of the enforcement authority. And so figuring out what that is and how widespread it is as well, that's another aspect. If it's one isolated incident in an operation that's not a large part of the global chain, that's another thing that you need to determine. And once you've kind of assembled those facts and you've made a decision about whether or not to disclose to the government, or maybe the government's already served process on the company, then it's a negotiation about whether you could start at zero, certainly. I mean, that's always a possibility depending on what the facts are, and walk away. That does happen, that there's a decline to prosecute, that the DOJ would come to a conclusion that this isn't a case that's worthy of pursuing. You also, there are various steps that are short of actually having a company take a plea. So you can have a deferred prosecution agreement or a non-prosecution agreement. There's a tremendous amount of negotiation that goes into what flavor those agreements would be. And then ultimately, of course, there's discussion about numbers. And those might, on the disgorgement front, might relate to how it is that you're going to calculate margins and you know, what types of revenues are going to be included and which aren't, what kind of costs are going to be included and which aren't. And then on the fine front, different type of calculus, but that's a little bit more maybe dependent on other similarly situated cases. So you sort of do a survey of other enforcement actions and try to determine what was an appropriate fine as the DOJ or SEC decided in some other case. That's kind of how one of those negotiations would work. But figuring out what happened is the most critical and the most time-consuming part of the entire process. It's also pretty hard to determine in many cases what actually happened.
I would just ask that you guys, questions, use the microphone so we can send it off to our webcast audience as well. Thank you.
It's a hypothetical. Your client doesn't self-report of a known violation, U.S. company, does business outside of the United States. How difficult it is for the DOJ to do an investigation? There's no paper trail, there's no self-reporting.
Mm-hmm.
Can't call you guys to do anything because no one's talking about it. There's no paper trail.
It's never that simple. There's always a paper trail because you're dealing with money. Because frankly, if you're going to pay a bribe of even if you take it out of petty cash, there's going to be some documentation of the petty cash going out. And what we've seen is once you pay one bribe, there's another, and it sort of builds on itself. In fact, there's a huge focus right now on small bribes, to be honest. And a lot of prosecutions you're looking at are taking bribes in multiple jurisdictions, combining them together and saying you've paid X amount. The issue of whether you, I mean, you're sort of driving at, do you self-report or not if you think you don't have to? That's a very complicated analysis, depends a lot on the nature of the business, the nature of the situation. I will tell you that if you decide not to self-report, you better do all of the corrective action that the DOJ would expect you to have done. So if you do get a knock on the door by members of the FBI, that you're able to sort of say, yes, we were aware of it, we identified the issue, we've taken corrective action, which is a nice way of saying we fired everyone involved.
Now you've got a disgruntled employee out there who may self-report for you.
Well, and we haven't touched on whistleblowers because there's now a fairly significant bounty if an employee blows a whistle on its employer who's making bribes. And so the advice we give clients is you can never assume that this is going to go in a black hole and no one's going to find out about it. You have to be fully prepared for the Department of Justice to find out about this, and you better be in a position to explain why you didn't self-report. And I think that's the only advice you can really give clients, because if you don't self-report, there's going to be the first question there the DOJ is going to ask when you do one of these dog and pony shows in Washington is, why didn't you self-report? And you better have a good answer, and then you ought to show all the effort you did to correct the action before you self-reported. In fact, we've gotten new matters because the FBI has showed up at the client's door and said, we understand you're making bribes in pick a country, and the client says, we don't know what you're talking about, and then obviously we do an internal investigation to find out. But the amount of cooperation between law enforcement agencies around the globe is absolutely incredible. if you have
Yeah,
anything
I was
to add to that.
going to mention the whistleblowers, but you covered that. So that's you know, no matter how well you think you've accounted for everything that happened, you cannot predict who would become a whistleblower, because the money that's being offered at this point in time for whistleblowers that result in a successful action is really, it's astounding. It's millions of dollars that's being offered.
Thank you. You know, one measure of evaluating the, maybe not the effectiveness, but the judgment of the Department of Justice in deciding to prosecute cases under this statute would be to look at the recent trials that have occurred. I'm not up on that, but I'm sure you gentlemen are. Can you talk a little bit about what's happened maybe the last several years in the prosecutions by the department against corporations and individuals, and how has that fared it out? Thanks.
Sure, yeah, I'll just briefly mention the fact that this is, surprisingly or perhaps unsurprisingly, it's a very under-litigated law. It's not one that is that companies are usually really excited about putting the government to their proof. But it's also a law that I can tell you, when I was with the Justice Department, that it was well known that it was not a statute that most prosecutors wanted to be in front of a jury trying, because it does not have a tremendous amount of jury appeal. I think the results are mixed. I don't know exactly what the stats are, but there was a run there about 2 years ago where there were a series of acquittals on FCPA cases, and some FCPA cases that involve, you know, wiretaps and informants and recorded conversations, you know, things that really are not normally in play in most FCPA cases. And the reason was the jurors looked at these cases and said what a lot of people might say, which is, well, this company's trying to do business in this country, and they're having to deal with all the same obstacles that not only foreign companies have to deal with in that country, but also companies within that country, nationals in that country. I mean, it's very common for people to have to pay a bribe or some sort of payment to get a driver's license or to get out of a parking ticket or whatever it is. And so I think jurors looked at these cases and said, this, thanks but no thanks. We're not going to convict on these facts. That's not to say that, I think there are cases that have plenty of jury appeal that are out there, but those are never going to get tried. Those will be negotiated and resolved.
They're usually, the cases that get tried are the individuals that get charged,
Yep.
because the Department of Justice has said the message isn't getting through when we just try to prosecute corporations, because it's just a monetary fine. So there's been a huge uptick in about, I think, the last 5
Yep.
years or so, where there have been prosecutions against individuals, in addition to levying large fines against the company. And the acquittals have come from individuals essentially saying that this wasn't my conduct, I wasn't trying to improperly influence someone, this is about my personal relationship with someone, not a bribe to obtain business. And there's been some success. I don't know what the stats are, but the department lost many more cases than they wanted to. In terms of corporations aren't inclined to try these cases. One, they're expensive. Two, the risk is very, very high. You have debarment and all of these other issues that come along with those issues. Plus, ultimately, there are some covenants in most of their financial obligations that if they're breached, ultimately their lines of credit cease to be operable. So the risk of the company is actually to the point where the board doesn't want to deal with this issue because it's too much enterprise risk to the organization. So they resolve it. The problem is when you resolve it, then you get a shareholder suit, you get a derivative suit, you get all these downstream effects. And actually, one interesting thing I'd heard about why the fines are getting so high, because when a public company announces an FCPA investigation, their share price drops, and then when they would announce that they resolved it, it would go up, and ultimately the increase would pay for the fine. And so one of the reasons the department, this is their argument, it's a pretty good one, that the reason that the fines are getting larger and larger is they want to make sure that companies cannot profit from the FCPA.
Excellent. Other questions? Yeah, Richard, please.
So you talked a lot about a bit that enforcement regimes globally are expanding, but you were mostly talking about G20 countries. What about emerging markets, specifically East Africa, West Africa, and Southeast Asia, that they're becoming more integrated into the global marketplace, but in many cases, I have some experience with Uganda, there is a nominal anti-corruption system, but its enforcement is still in the works, and many would still look at Uganda and or a country in its position and say, of course I have to pay a bribe. What experience have you seen in these emerging markets that are now becoming more closely tied to the U.S., NAFTA, EU, et cetera?
Yeah. Well, just real quick to follow on Colin's point about the enactment of all these anti-corruption statutes worldwide. It's true that you've seen a real sea change in terms of laws on the books. But even if we take the China model, for instance, where there has certainly been a higher degree of enforcement of their anti-corruption laws, still, in many cases, you could see that some of that enforcement might be selective. It might be selectively targeted at multinational companies, particularly in various industries. It seems like, there was like an Industry of the Year function there that was going on for a while. It was pharmaceuticals. Who knows what it's going to be next? But it's not necessarily what you would expect from, say, a Western law enforcement agency, where it's absolutely everything is investigated and pursued. It appears to be much more selective, if it's enforced at all. And so, and you mentioned Uganda, you mentioned Africa. Again, it's going to depend quite a bit on resources. So some of these countries have fairly robust anti-corruption programs because they've been funded in large part by the United States or OECD or the UN or whatever it may be. So they may be a little bit more inclined to enforce the laws that are in the books, or able to, really, is what the watchword is. That's my response there.
It's harder in those sort of emerging markets, China's obviously much more developed. On a recent FCPA case, we had a team of folks go to Nigeria right as the Ebola thing was breaking, so the timing was ideal. They were there on an FCPA matter. It got to the point where they were counting up the number of times they were asked for a bribe, and they got into significant numbers. Small bribes, but still, it's just part of that culture. I think those developing parts of the world are lagging behind, obviously, the other parts of the world. I think that you're seeing a lot more sophistication in what's being required of these different countries. And in fact, the World Bank, if you're going to accept money from the World Bank, they actually force you to put in place an anti-corruption regime. And in fact, have monitors come in and actually check and audit to make sure that these companies are actually, or these countries, companies, both sides of it, are actually engaging in fair business practices and not engaging in corruption. So you're seeing it penetrate all the way through around the globe. The reality is some countries are much more aggressive in the enforcement than others. Just because you haven't the law in the books doesn't mean it's going to happen. We've had situations where we've had clients asked for bribes by the prosecutor. We've had, things like that happen. We've had situations where in Mexico we were dealing with a situation, and I would call a Mexican set of lawyers to help us, and they would tell me the better way to pay the bribe. And I said, no, I started the conversation by telling you we weren't paying any bribes. He says, no, we understand that, but here's how we can do it. Thank you very much. I went through 4 sets of lawyers to get to one guy who said, okay, I understand, we're not going to pay bribes. The world's a very different place, and each country has its own cultural and historical sort of viewpoint, but it's tricky doing business abroad, and frankly, you learn very quickly that every country is very, very different.
I know there have been recent prosecutions in both in Nigeria and in Indonesia. So in Indonesia, for example, a Japanese company, so no American companies, Marubeni, a Japanese company, and Alstom, the French electricity company, were recently caught up in FCPA for bribing Indonesian electricity officials. So maybe the more advanced emerging markets are now sort of coming under the radar of the
And
DOJ.
most of those were self-reports, though. And many of those were self-reports by the. So you end up with payments being made in those countries and then self-reporting in the U.S. or otherwise. And then, so you get, most of the payments you're seeing now are in the BRIC countries or in the emerging markets. So when I say, I think everyone knows what BRIC is, but,
Okay, good. Colin, do you want to ask?
I have a question about the value and purpose of the FCPA. As you all have mentioned of China, and I'm also from China, I can say one thing. The FCPA has minimum, if any, effect on the tightening of the anti-corruption law in China. So really, the FCPA only restricts US companies. So how can it promote the anti-corruption law in other countries? In my opinion, none. But still, it can't be like Americans are noble people, so we don't do corruption. We don't bribe foreign officials. I think that can't be the case either. So may I suggest that it is because, as you have mentioned, that the FCPA generates a lot of fines. So is it maybe, I'm just suggesting, no offense, it's a way of fueling the government with a lot of fines. So can you explain to me what is the ultimate purpose of this law?
we're going to need a beer or two over that one. You want that? I can do that.
Well, I can, do you want to weigh in on that? Well, I'm not eager to jump on
Well,
this one,
everybody's
but-
jumping. Well,
I mean,
I'm not qualified to comment on international effects of laws. I'm sure there's some professors here, maybe like this,
yeah.
maybe Professor Webster
I'll take the
could
mic.
come on it. But my cynical side said yes, it's that the U.S. government uses the FCP as a revenue enhancing tool. But I think as we heard Professor Webster when he introduced the topic is, remember what this law was enacted was in the late 70s in response to a specific sort of number of issues of bribery, and it was of such a magnitude, and again, I'm sure, Tim, you've probably got the list of all the companies that did. It was of such a magnitude that it sort of, what's that phrase, shocked the conscience. I don't think it was ever meant to be enacted to be, this is an American regime we're going to impose on the world. We're going to impose this on American companies. The fact that the OECD and a lot of other countries have now enacted anti-corruption regimes, I think, again, and I'm not an economist, but I think as a result, there's been a lot of study by economists that shows that the effects of corruption is that they're very distorting in most economies, and they're particularly distorting in developing economies. But again, I'm just a plain old commercial lawyer, so.
Ultimately, the anti-corruption laws are meant to generate a fair marketplace so that the goods and services are bought and sold at fair prices, and that the person who's most competitive gets that work. In the FCPA was the first of these regimes to be passed. I've seen lots of Americans bribe, so it's not that there's frankly a lot of our work is domestic as well. And one interesting thing is that the Department of Justice has recently said they're going to use the accounting provisions, which essentially says that you need to keep accurate books and records if you're a publicly listed company in the United States. And if you don't, even if there's no bribe, if you don't have sufficient internal controls to prevent or detect a bribe, that in of itself is a violation of the accounting provisions. But what they're saying now is the accounting provisions, they're going to use those to also prosecute commercial bribery. So that if you don't accurately reflect it, and I have, like Justin said, you actually have to put in your records, facilitation payment to so-and-so in order to get goods shipped out. You see that, Ernst & Young, whoever is your outside accountant's going to go, stop, wait a minute, we need to figure out what's going on. And one issue that we've all got in terms of dealing with large companies is the auditors get very interested very quickly about these issues. So you not only do you have to deal with the U.S. government, you have to deal with your auditors, you have to make sure your books and records are accurate. So it's a very complicated issue once you start kind of peeling back the onion. I think that there's been a lot made of the sort of the crackdown on anti-corruption in China. I think that is not a direct result of the U.S. FCPA. I think that's a direct result of China's emergence as a world power in the economy, and they want to make sure that it's free for investment from around the globe. And there's always sort of been a crackdown whenever there was a change in the chairman or the president. This has a different flavor because it's no longer looks like it's politically motivated. It looks like it's real substantive cultural change in China. And so hopefully that answers your question. There was a lot in there, but if you've got any follow-up, just let us know.
And I'll just say, with respect to the size of the fines, I mean, there's no question that these fines are enormous. And that seems to be the trend in some of these big industry cases, that the government is seeking higher and higher fines. I mean, $15 billion from banks, you know, that's just the word of the day. And whether it's, you could take a cynical view at it and just say that that's a bigger number to guarantee you get a headline and there's a press release. I think it's...
You never would do that sort of thing, though.
No,
You
I would not.
Press release is written before the indictment, but
Yeah. But, you know, there is also, in terms of fairness, and that's the dollar number these days. It's a high number. I don't think that anyone's going to say credibly that the U.S. government's trying to balance the budget on the backs of these fines, because in the overall picture, they're not a very large percentage of even any individual agency's budget. But they do tell a story. I mean, you don't forget that there's budgets that are in play here. And if the Justice Department can come in and say, hey, look, we collected $20 billion in fines last year, and oh, lo and behold, look, that's more than what our annual budget is. I don't know if that's true or not. This is an example. That's a good argument for them in front of Congress if they're asking for more money. But ultimately, the numbers are not just a product of seeking ever higher numbers. They're also supposed to be grounded in other punishments that have been exacted against companies that were similarly situated.
yeah, law enforcement is a profit center. It's new. It's good.
Yeah, I mean, I would echo what all of the panelists have said and just add that, as Kevin mentioned, it was passed at a particular moment in time. Laws very rarely die. They're just repurposed for other functions. So FCPA, Colin said it's antiquated, it needs to be retooled. It's been retooled several times since, and again, things like grease payments, that was a later amendment. They said, okay, you know what, we're having a problem here, we got to amend the law to allow grease payments, right? So then we have this grease payment exception. So, and again, these huge multi-hundreds of millions of dollars of fines is a function of the past 5 or 6 years. So, you know, there's a history, and there's the enforcement of the law itself changes to the particular administration that's enforcing it. I think we have time for one last quick question if anybody wants to weigh in or make a comment. Yeah.
Well, this will have the advantage of being a quick question. Mr. Jennings, the guy on the dock wants a bribe and you say, no, we're going to go to your supervisor. And that works unless the supervisor wants, why don't you just keep going to his, all the way up to the top?
We've done that. Sometimes it works, sometimes it doesn't. Sometimes you get crickets and no real response. Other times you get a very quick response. Next thing you know, someone else shows up the door saying, hi, I'm the new supervisor, when can we help you? It really depends on the country. It depends on the politics and the relationships and the personalities involved. And one thing, Americans are not particularly good at being culturally sensitive when they're doing business in other countries. We're getting better at that, but oftentimes we show up and say we're going to do it this way or else, and frankly that lends to the crickets and no real response. So we're getting better at being part of the global economy, sitting down with people and making sure that we don't run into these issues ahead of time and kind of make sure that we've kind of got the process cleared away, because the facilitation payments, this was not a facilitation payment. This was a very significant ask in order to get them off. But the facilitation payments, most of the world regime doesn't allow facilitation payments or grease payments. So if you're a multinational, you violate the UK anti-bribery law by paying a facilitation payment, or you violate the Brazil Clean Companies law by paying a facilitation payment. You just can't do it anymore. It just doesn't work. And so what you sort of have to do is really trust that you're doing business in a country that's not going to expect you to pay bribes, and that's why going up to supervisors. We've actually had situations where we've gone to the U.S. ambassador who's talked to other folks, and that's helped clear the way too. It really depends on the scale of what you're dealing with. If you're dealing with one shipment, is it easier to leave it there? or are you really worried about your entire supply chain? If you're worried about your supply chain, you're going to continue to climb up the government ladder until you find someone who's going to be helpful to you. But it's not always that easy, and it's politically and culturally very tricky because there are a lot of traps.
Excellent. Colin Jennings of Squire Patton Boggs, Justin Herdman of Jones Day, and Kevin Barnes of Taft, Stettinius, and Hollister, thank you guys for coming and enlightening us with your
All right, thank you.